who may be joining us today in this webinar. Hello everyone, and welcome to Mind Your Money, How to Manage Your Finances and Other Life Decisions webinar, which is being presented by the Alliance of the Prevention of Elder Abuse, also known as APEA. My name is Caroline Barkla, and I am the Chief Executive of Age Rights Advocacy Service. I would like to thank everyone who registered for the webinar and for joining us live. Just a reminder that we are recording today's webinar, and we will share the recording with you after the event is complete. We welcome you to revisit the content yourself and share it with your networks. So APEA comprises of Age Rights Advocacy Service here in South Australia, the Legal Services Commission in South Australia, the Office of the Public Advocate, the Public Trustee, and South Australian Police, known as SAPOL. APEA was initiated by ARIS in late 1998 with the 5 South Australian agencies who work on the front line, combining their efforts with a view to improving and challenging the way the abuse of older people was understood and addressed. APEA's focus has and continues to be on prevention strategies and collaborative responses to financial abuse. Since its inception, APEA's achievements have been many and include statewide education sessions and presenting at many community forums, state and national conferences. Before we get started, we just have a few more housekeeping topics to cover. We invite your questions. Please look at the Q&A box on your screen. If you think of a question for the speakers at any point, just type it in there and I will pose it during the Q&A portion at the end of the webinar. If we don't get to those questions, we will certainly come back to the group, and so feel free to pose those questions. There is a checkbox on the Q&A if you want to write anything anonymously. So let's get started. I would like to introduce our first speaker, Doris Geoffrey, one of the 6 team leaders at Age Rights Advocacy Service. Doris joined ARIS in 2002 and with a degree in social science has held various roles with a diverse range of responsibilities, primarily as ARIS's subject matter expert in elder abuse prevention. Doris has developed and facilitated delivery of elder abuse prevention training to aged care and allied health workforce, and has presented at national and state conferences for World Elder Abuse Awareness Day. The title of Doris's presentation is Knowledge is Power, How to Safeguard Your Future. Over to you, Doris.
Hello, everyone. Thank you for joining us. ARIS has been holding and supporting older people's rights since 1990. So I've been around for almost 2/3 of those years, and I've been here, I know, for a very long time because I truly believe in what we do. I do believe that advocacy support does work, and you can only just see the people's faces, how happy they are when they've received a very good outcome. So I'm so passionate about advocacy. So the focus of my presentation today is to provide you with information on how to safeguard your future. After all, knowledge is power, and understanding your rights is the first step to safeguarding your future. So I must thank our funding body for our existence. So ARIS is funded by the Australian Government Office for Aging Well, SA Health, and the Primary Health Network. ARIS is the South Australian member of the Commonwealth-funded Older Persons Advocacy Network, also known as OPAN. OPAN is made up of 9 community-based organisations, and there's one in each state and territory, and we work together to deliver a free, national, consistent advocacy information on aged care services and education to older people across Australia. These are currently our key service areas. So advocacy support is provided to those who are receiving or seeking to receive aged care services in residential or community, such as Commonwealth Home Support Program or the home care packages. Those who are 65 years and older and 50 years and older for First Nations people who are experiencing or are at risk of experiencing some form of abuse by someone they should be able to trust, and those who are living in a retirement village. We also have Aboriginal advocates who provide advocacy support in a culturally sensitive manner across all of our key service areas to First Nations people and their representatives. Other services where we also provide advocacy support include assistance to connect vulnerable older people with My Aged Care and identify what aged care services is best to meet their needs. Currently, we are funded for those who are in the City of Salisbury and City of Playford regions. Home care check-in for vulnerable older people who are socially isolated and are at risk of harm or neglect. Information and advocacy support if you have any concerns on aged care fees and charges. How can you take control of your life? Well, you can take control of your life by ensuring that your voice is being heard on the things that matter mostly to you. So take action rather than waiting passively for them to happen. Now, I know that's easier said than done. At ARIS, we can provide you with information to self-advocate if you feel that you have the confidence to do this, or we can provide support to advocate on your behalf so that you do not need to feel as if you are alone. However, you are still in the driver's seat and we are guided by your wishes. So you may be asking, how does ARIS Advocates provide advocacy support? So the advocate's role, firstly, we always meet with the client face-to-face in their home, in a residential aged care home, or in a retirement village, with all matters treated confidentially, and will only disclose information to other parties with the client's consent. So the role of the advocate is to take the side of the client and work at their direction or their legal representative. Take the time to listen and understand the client's views and wishes. Assist the client to explore their options to enable them to make an informed decision. Provide practical assistance, for example, support the client at an appointment with a legal service or at SAPOL if the older person is needed to make a report at a police station. Provide practical assistance. I've already said that, for example, in regards to meeting clients at the service, legal service, or at a police station. Establish an action plan, which is always done in consultation with the client. ARIS will also provide a professional interpreter if requested at no cost to the client. We will never use family members for obvious reasons, especially if it is an abusive situation. We don't know what the family member is interpreting to the older person, so we will only use professional interpreters. So advocates can also meet with third parties, such as a service provider, with the client. Clients do feel safe when working with an ARIS advocate, as all advocates are professionally qualified practitioners and have undergone police clearances. How do rights apply to situations in your life? We all have the same human civil rights, no matter our age, where we live, or what our culture is. However, if you are receiving aged care services, you have an additional 14 rights and include, now I have chosen 8, but there are 14. So safe and high quality care services, to be treated with dignity and respect, which is so important for elderly people, have your identity, culture, and diversity valued and supported, live without abuse or neglect, have control over decisions about your financial affairs and your possessions, your independence, be listened to and understood, and complaint free from reprisal. Knowing your rights is a way of minimizing the likelihood of elder abuse. Knowing your rights means being aware of those personal and health decisions and actively deciding how you want to deal with them. Knowing your rights means that you can act to make sure your rights are respected and your later life is lived the way you choose and how you want to live it. Sometimes family can place pressure on you to make changes or decisions as you get older. You have the right to make your own decisions about every part of your life. If you feel unsure of what to do, please seek support and call us. The new Act will be underpinned by a statement of rights which outlines what older people can expect from registered providers in the Commonwealth aged care system. Older women are more likely to experience elder abuse than older men, with a 60% female to 40% ratio. And most abuse is intergenerational, that is, involving parents and adult children. Now, with this definition, it includes 2 major points. One, that an older person has been abused and has suffered injury, whether that is psychologically, physically, sexually, socially, financially, or neglect. Most forms of abuse reported to ARIS by our clients is psychological abuse, followed very closely by financial abuse, and social abuse, including isolation and neglect. The other major point that I'd like to mention in this definition is that another person or persons in a relationship of trust was responsible for causing or failing to prevent the harm that is experienced. This relationship of trust is usually a family member, unfortunately, such as a son or a daughter, or it could also be an aged care provider. Adult children, however, are reported as the main alleged abusers. In fact, it is estimated that 80% of our cases, the alleged abuser is by immediate members, including the spouse. Therefore, any abuse by strangers is excluded from this definition. So the National Elder Abuse Prevalence Study, this was done in 2021, states that 1 in every 6 people over the age of 65 experienced abuse during that 12-month period of the prevalence study. Most common forms of abuse was psychological, followed by neglect, whereas with ARIS stats, the common forms of abuse is actually psychological and financial. And the most common abusers were adult children, followed by friends and neighbours. And only a third of victims were seeking help from a third party, unfortunately. But I would also like to add that with the prevalence study, which was conducted by the Australian Institute of Family Studies, people with dementia were excluded from that study, as well as those who resided in residential aged care facilities. I'm just going to go through a typical case that the advocates would work on. So obviously the case has been de-identified. So Esther's son, Miles, visits her every week with her grandchildren. On occasion, he has asked for money for expenses, and Esther is happy to help out when she can. However, requests have been more frequently and of larger sums. When Esther explained that she couldn't afford to continue doing this, Miles became angry and stormed out with the children, not returning to visit her for 3 weeks. Most recently, Miles had been asking Esther about the equity in her home and pressuring her to sign the title over to him, stating that he will inherit it anyway. Esther wants to help her son, but is concerned about the repercussions, whether she lends him money or not, and possibly seeing less of her grandchildren. Esther phoned Aris after hearing on the radio about the service. At a face-to-face meeting with Esther, the advocate took the time to listen and understand Esther's situation with no judgment of her situation or that of her sons. Esther was reaffirmed of her rights, including not to sign or take action under coercion. At all times, Esther's sense of control and rights in the advocacy process was affirmed. So just want to talk to you about informed choices. And when it comes to safeguard, it is important to plan ahead and consider careful completion of appropriate documents, such as an advance care directive and enduring power of attorney documents. On our website, you will find a resource developed by a peer called Recipes for Living Well. If you give Aris a call, we can post these out to you if you can't download them. Now, we do have expert speakers in regards to advanced care directives and enduring power of attorney, so I'm not going to delve into them too much. However, before signing any legal documents, please seek legal advice, as documents such as an enduring power of attorney can be used against you if it is not done correctly. If you are informed and aware about your finances and legal affairs, people are less likely to take advantage of you. Ensure that you have the final say and control. Remember to document decisions, including loans or gifts to family members. In any of these situations, again, seek legal advice before signing any documents. So Aris always promotes safeguards when we're talking to our clients. So if we encourage people to plan for the future, consider making advanced care directives, enduring power of attorney, and ensure that your will is up to date with any changes in your life. Decide on your preferences and let others know of your decisions. In particular, provide your GP with a certified copy of your advanced care directive, as well as your bank manager with a certified copy of your enduring power of attorney. Your GP and bank need to know who is acting in your best interest if you are no longer able to make those decisions. Also, remain active in the community. Maintain your social contacts. It is so important. Develop friendships outside your immediate family. Be involved with community activities. Isolation can increase older person's vulnerability. Be as independent as possible. Take care of your own health by eating healthy and keep up with your regular health checks with your GP. Ask for help from services when required so that you are less dependent on family members for social activities, for medical appointments and so on. Think carefully before accepting personal care in exchange for your possessions or accommodation. And finally, plan to be safe and feel safe in your own home. Consider ringing SAPOL Home Assist, who will do a free safety audit of your home. You can call Aged Rights Advocacy Service. All our contact details are on our brochures, and we do have brochures in lots of other languages which are on our website. Aris affirms throughout its advocacy support processes a clear message. There's no excuse for abuse. Something can be done about it, and help is available. So please call us if you know of someone who is being abused and would like our support. Thank you.
Thank you, Doris. I would like to take this opportunity to talk about the only conference of its kind in Australia, which is being co-hosted by Aris and EAAA, which is Elder Abuse Action Australia. The conference is titled Turn Up the Volume, 2024, and it's on in Adelaide between the 22nd and 24th of July. The conference will attract internationally renowned experts and professionals, including our keynote speakers being Jane Caro, AM, and Tracy Caro. Read more on the conference on our website or the conference website. So it should be an inspiring older persons led conference. So please, we strongly encourage you to attend. So now I'm going to turn to our next speaker. And our next speaker is Paul O'Connor, solicitor from the Legal Services Commission, and of course, one of the key partners in Appear. Paul O'Connor has been practicing as a solicitor in South Australia since 2009. Paul has been working in the community legal education team at the Legal Services Commission for the last 2 years and has led the development and delivery of the legal education sessions tailored to assist South Australians as they age. Paul's presentation is Enduring Powers to Intervention Orders, Legal Tools to Live Well. So please welcome Paul.
Thank you very much, Carol-Anne, and good morning, everybody. I'll just make sure I can do the sharing of my screen.
And we need your camera on too.
Ah, has that gone off?
There we go, you're sharing your screen. Great.
Beautiful. Okay. So, as Carol-Anne mentioned, I'll be talking today about enduring powers of attorney and intervention orders and how they relate back to the topic of what we're talking about today, minding your money. But I wanted to start by first talking about who the Legal Services Commission is, as I'm conscious that that's not always a name that people are familiar with. So,
Paul, sorry to intervene. Sorry, would you change the display settings?
Ah, of course.
Thank you.
Thank you. So this is the Legal Services Commission. Our tagline is at the top there, legal help for all South Australians. And as you can see on that slide, there are a number of ways in which we can provide that legal help. Some of the services that we have do have different eligibility criteria. But the service that I want to focus on is the first service there, a service that has no eligibility criteria whatsoever. Everybody is eligible to contact the Legal Services Commission to access free legal information and advice. And this really goes back in many ways to what Doris was talking about in her presentation, that relationship between knowledge and power. We believe that everyone has the right to information and advice about the law and what it says. We want to make the law accessible to people so that they can understand their legal rights and responsibilities. So as a starting point, anybody can call our free legal advice line on 1300 366 424 and receive free, confidential legal advice about most legal problems. As you can see on the slide there, that we have facilities for people who may need the assistance of an interpreter or people who may be hearing or speech impaired. No appointment is necessary to contact this service. You can simply call and access that preliminary information and advice. If you do want to make an appointment, then we do offer either a face-to-face appointment or telephone appointments. Again, you can make contact with us by calling that number. We can set aside some time, more time than would be available if you were to contact the legal advice line, to unpack the legal issues that you have, or consider paperwork that you may need assistance in understanding. Now, this is not to say that we will necessarily be able to resolve every legal issue in an appointment or a phone call. But what we can do is at least look to provide you with a starting point, with the initial information that you may need, and then point you in the right direction so that you can be informed in the decisions that you make to protect your legal interests. And so protecting legal interests brings us back to today's topic and the legal tools that I want to give an overview of. So if we first start with an enduring power of attorney, or rather just look at what is a power of attorney. A power of attorney is a legal tool that you can use to create a formal legal arrangement where you appoint a trusted person or persons to act on your behalf in relation to your financial and legal affairs. So essentially, it means you're giving somebody else the power to be able to access your accounts, pay your bills, manage your money, manage your property investments, sell assets or buy assets on your behalf. What distinguishes an enduring power of attorney from what would be called a general power of attorney is simply put that an enduring power of attorney will survive if somebody loses capacity. What I mean by that is that the powers that you give somebody under an enduring power of attorney will continue to operate if you lose capacity. Under a general power of attorney, those powers would cease when somebody loses capacity. And when I'm using the word capacity, I'm talking about it in that legal sense, which in essence means the ability to understand the nature and effect of a decision and the ability to communicate that decision in any way. And this is what makes it such a useful tool when we are planning ahead for the uncertainties of the future. Whilst you have capacity, you can set up this formal legal arrangement, you can appoint the people or person that you want to have the responsibility of your legal and financial affairs. And it can allow for that seamless transition as to who should have responsibility for these matters if through illness or injury you were to lose capacity. It can get rid of that dispute that may arise in a family about whose responsibility this should be when a document like this is not in place. And there are two ways in which you can create an enduring power of attorney. You can create it so that it commences immediately and then would continue to operate when you have lost capacity. Or you can make it so that it only begins at the point where you have lost legal capacity. Another important part about an enduring power of attorney is that you're not simply just passing these powers to somebody else. With these powers or the passing of those powers come important responsibilities. So essentially what these responsibilities boil down to is that the person you give the powers to has to do exactly what the topic of today's webinar is. They have to mind your money. They have to exercise their authority with reasonable diligence to protect your financial and legal interests at all times. As part of this, they have to keep accurate records. And if you were to lose capacity, they can't simply leave you high and dry and simply stop performing their duties. They would need to make an application in order to relinquish their powers. So that's all the good news. But in many ways, Doris has already stolen my thunder in relation to what the bad news is. Doris has laid out that financial abuse is unfortunately a very common form of abuse that older South Australians or older people generally in Australia experience. And it's not the case that simply drafting an enduring power of attorney and not getting legal advice or not turning your mind to some of the risks involved will necessarily be enough. You need to make sure when drafting the document that you're drafting it to do what you want it to do. And in many ways, that speaks to the importance of this. Like any legal arrangement, it's important that everybody involved in it enters it with their eyes wide open. What we're trying to suggest is avoiding that situation where we approach a loved one, we ask them if they will be our attorney, and they say, yep, sure, I'd love to do that for you. And they sign the document without knowing what they are really being asked to do. They don't necessarily know what would happen if the arrangement breaks down. And in some instances where an enduring power of attorney is misused, it's not as a result of an intentional desire to do so, but sometimes because the person involved, the person we have appointed, simply doesn't fully understand what their rights and responsibilities are. And that may allow for things like inheritance and patience to begin to creep in, for conflicts of interest to arrive. So it's equally important that when we ourselves are creating the document, that we're aware that whilst we have capacity, that we can cancel this document at any time. If, for example, the person we've appointed encounters significant financial stress, we might want to reconsider the person that we've appointed. We might want to consider whether we are exposing ourselves to an unnecessary risk. It's important to get advice as part of this for ways that we can then look to safeguard our interests during periods where you may have lost legal capacity and you aren't necessarily in a position to cancel the document yourself. And there are a number of ways that you can do this. Again, it's important that you get advice specific to your circumstances. It's not a case that one size is necessarily going to fit all. Again, to link back to what Doris was saying about the importance of maintaining a wide social circle as we age, it also speaks to the importance of, as part of that, where possible, letting other people know about the existence of this legal arrangement so that there's other eyes and ears around us, so that if we ourselves aren't in a position to identify misuse, others may be on guard to do so on our behalf. Equally, you can look at appointing more than one person to be your attorney and requiring that they act jointly so that one acts as a safeguard on the other. Or you could include instructions for third-party checks of your accounts, knowing that that will include a financial cost as part of that. Again, the importance of getting advice specific to your needs. I've put up there on the slide a publication created by the Australian Guardianship and Administration Council called You Decide Who Decides. It's available on their website, a very helpful resource for people looking for more information about the things that we can do or the considerations to keep in mind. We've also created a do-it-yourself kit that the hard copy costs $22, but importantly, to mind your money, it's available for free from our website. You can download it and print it out. Again, though, the importance of seeking legal advice. But then what about a situation where our arrangements have broken down, when we or a loved one are being subjected to abuse, whether that be financial or otherwise? That brings us to our second tool, an intervention order. People may be more familiar with the term AVO or restraining order, but the courts in South Australia, we call them an intervention order. And again, Doris gave an explanation for what abuse is, how it can be patterns of behaviour, how it can relate to exploitation of power imbalances. And importantly, intervention orders, they are specifically designed to protect individuals from acts of abuse. And that definition of abuse is very broad. There is a recognition that it can be subtle. There's a recognition, again, that it goes back to those power imbalances within a relationship, and that it can consist of a pattern of behavior. It also recognizes that abuse isn't just something that results in physical injury or the damage of property. It can be emotional, it can be psychological. It can be about removing our own autonomy, our ability to make our own decisions. Indeed, the law in relation to intervention orders specifically uses the example that causing a person through fraud or coercion to relinquish control over assets or to sign a power of attorney is an act of abuse. The way an intervention order works is that it imposes conditions on the person responsible for the abuse. It doesn't work to punish previous abuse that has occurred, but rather it imposes requirements on them to do certain things or not to do certain things in order to prevent future abuse. For example, not to contact somebody by any means, or alternatively, contact is allowed, but it's only allowed by text message. The idea is that these orders can be developed to shape the needs of the person who is seeking the order. Now, I'm very conscious that it still involves accessing a legal process, and that can be difficult where the person perpetrating the abuse is a close family member. It may be accessing support through ARIS and advocacy may be a preferable option. But importantly, the creation of an intervention order is not a criminal matter, and that's where sometimes it can have some appeal. It only becomes a criminal matter if the person who the order relates to, who the order restricts, breaches the order. Then it becomes a criminal matter. So again, it may not be for everyone. There may be other responses are appropriate. But going back to Doris and knowledge is power, there is power in knowing that this is a legal option. And there is power, and I know I'm beginning to sound like a salesman here, in knowing that you can contact the Legal Services Commission easily, quickly, for free, and get that idea of what your legal options are. Thank you, everybody.
Thank you so much, Paul. Really appreciate that presentation as well. So we are running a bit behind time, but I have I'm hoping everyone will stay with us because I'm intending to give all of our presenters their full time. So we will run over. So our next speaker is Kate Jensen, Manager of the Office of the Public Advocate. So Kate has been the Manager of Dispute Resolution, Information and Customer Services at the Office of the Public Advocate. Kate has a legal background and many years' experiences mediating in many fields, including family, older persons and human rights. Her title is Advanced Care Directives and the Importance of Planning. So welcome, Kate.
Thanks, Carol-Anne. Thank you very much for that lovely introduction. Thank you, Paul and Doris, for your really insightful and comprehensive presentations. Carol-Anne, just remind me of my time so that I can really, because I know you're a bit behind. So I'll put my little timer and I'll go through and make sure.
So you have about 10 minutes.
Okay.
And we just need you
to go. Yes, if I can.
Share your slides. Thanks so much, Kate.
All right, bear with me, everyone. This is not my forte, IT. My forte is in mediation and dispute resolution. So let's see how we go. Okay. Is that working? Can everyone see that?
No, we can't see that.
Not yet. Okay. Escape. No. Sorry, guys. This is all right. Let's go back again.
Technology. Oh, yes, it started.
Yay. Yay. Okay, fantastic. You can see, are we on the first, hang on. Is it showing we on the first page?
We are.
Yay. Okay, and if I do that, am I moving? Yay. All right. Thanks, everyone. All right, today I'm going to be talking about advanced care planning and the importance of it and advanced care directives. And I'm noting my time at 10:41, and I'll try and go through as quickly as I can. I always start by saying that when I do these presentations out in the community, I ask people to put up their hands and say, who has a will? And everyone diligently puts up their hand. And then I say, who has an advanced care directive? And I don't get a lot of hands. So I say, well, are people more interested in what happens when they die than what happens when they're still alive? And so I'm very passionate about advocating for people to do their advanced care directives because it does assist with some of the things Doris talked about with preventing abuse, and it is a tool you can use, a legal tool you can use to document your wishes for when you're still alive, but for a time when you might not be able to make your own decisions. You can appoint somebody to do that for you, and I'll go through in a bit more detail and explain that a little bit more step by step. But I thought I'd better start with what the Office of the Public Advocate does, because a lot of people don't know, and I think the title itself is a little bit misleading. So our public advocate, it's a statutory appointment, and the main role, although we feature in several pieces of legislation, or the public advocate does, is to promote the rights of people with impaired decision-making capacity, and to assist people, family and friends who have impaired decision-making. The public advocate's mentioned in several pieces of legislation, as I said, but the main one is the Guardianship and Administration Act. And our public advocate has a few functions. And again, so advocacy is absolutely one of them. But actually, our main function is that we can be appointed, the public advocate can be appointed by the South Australian Civil and Administrative Tribunal as a guardian, and to make decisions for somebody who's not able to make their own decisions anymore, so has impaired decision-making capacity and needs assistance with decisions around where they live, personal decisions, and health or healthcare decisions, and or all of those decisions. So, and that's if there's nobody else willing and available to do that, and or they haven't made an advance care directive. So I always start by saying, by telling what can happen, that the public advocate can be appointed guardian, and then saying, but if you make an advance care directive, document your wishes and nominate who you want to make those decisions. And the chances of a public body being appointed to make those decisions on your behalf is much more limited. Okay, so what is an advance care directive? So it is a legal document, and the legislation that governs it is the Advance Care Directive Act in South Australia. So I'll be really clear that this is a South Australian piece of legislation, and other states have different similar pieces of legislation. You have to be over 18, and you must use the official Advance Care Directive form, which was recently updated. So there was some minor changes to the legislation recently, and it was the form and kit was newly designed. I think it's much easier to read and much more accessible now. And I think Paul talked about where you can get some copies of that from Legal Services as well. If you made an old enduring power of guardianship or a medical power of attorney or anticipatory document prior to 2013, prior to the Advance Care Directive Act coming into play, that is still valid, and it's considered an advance care directive, and the people you appointed are considered substitute decision makers under this piece of legislation now. So this is a document where you can record your choices about your future healthcare, end-of-life decisions, preferred living arrangements, any other personal matters that you want in this document. And you can appoint somebody to make those decisions on your behalf. And we'll talk about substitute decision makers in a minute. Some examples of things you can record are where you want to live in the future. So you might say, no, I really love living down the beach, and that's where I've always lived. Henley Beach is my area. If I have to go somewhere else other than my home, I want to be down that way of town, that side of town, because that's where all my favourite people are, all the local people that I know. You can say who you want to spend time with for a time when you might not be able to say who you want to spend time with. So lots of people might say, I want to have all my family, all my grandchildren always visiting me on Sundays. You might say that, you know, a religion's really important to me and I want to be able to attend my local church. All sorts of things. My mum, for example, she loves her garden. She's written in her advance care directive that if she can't be at home forever, she wants to have a place, she wants to be in a place where she has access to a garden. They're the types of detail that you can put in an advance care directive, as well as very important decisions about how you want decisions to be made at the end of your life. You're the only one that can make an advance care directive. A family member and a friend cannot make one on your behalf. Okay, so you don't have to, but you can appoint substitute decision makers to then make those decisions on your behalf for a time when you can't make those decisions. Okay, so later if you become unwell or injured and you can't make a particular decision, your substitute decision maker can have a look at your advance care directive, see your wishes and make that decision for you. They have to make the decision you would have made, not the decision they think's in your best interests or a decision they think is an important decision to make for you, but the decision you would have made. This is really interesting, and a lot of people don't know this, but a substitute decision maker appointed under an advance care directive has exactly the same authority as a guardian appointed by the South Australian Civil and Administrative Tribunal. And really importantly, and I'll skip through this a little bit, but as Paul, not Paul, who was our person, Legal Service? Yeah, Paul from Legal Service Commission talked about the responsibility of attorney appointed under enduring power of attorney. Under the legislation, it's very, very clear that a substitute decision maker must uphold your values and wishes, must avoid any outcomes or treatments that you have written in your advance care directive that you didn't want to have. Make sure that your wishes are upheld. Make decisions you would have made. And if it isn't clear in your advanced care directive, specific wishes, they must consider any past or present wishes that you had and any values that you've displayed in your life. The onus in the legislation on a substitute decision maker to uphold your wishes is very strong and very clear. And to assist substitute decision makers, and if you're making an advanced care directive and appointing people to make decisions for you, you can direct them to this toolkit that we've developed recently. It's a booklet, some fact sheets, conversation starters, and some videos of substitute decision makers to help substitute decision makers. Because a little while ago, when the Advanced Care Directive Act was reviewed, Professor Lacey back in 2019 made some recommendations, and one of them was that there wasn't a lot of information out there for substitute decision makers. It's a really big, responsible role to make decisions, personal decisions for somebody else. And so we've developed this toolkit. So go to our website if you'd like to have a look at that. Paul's already done this really well, but just pointing out that an enduring power of attorney doesn't cover decisions about your health, accommodation, or life or personal affairs. Lots of people will wave it around and say, but I've got an enduring power of attorney, I can make the healthcare decisions. No, you absolutely cannot. And equally, an advanced care directive doesn't cover financial and legal decisions. They're two very separate documents. I think a really important point, and I'm conscious of time, but a really important point is that an advanced care directive doesn't get activated like Paul explained an enduring power of attorney does, often with a medical receipt, a medical opinion from a doctor saying that they don't have capacity to make decisions. The very important thing about an advanced care directive is that it's decision specific. So your substitute decision maker will only step in when there's a specific decision that might need to be made and you might not be able to make that particular decision. It's not a blanket, you suddenly can't make any decisions and your substitute decision maker makes all your decisions. It may be that you can consent to the flu vaccine, or you can consent to something really simple like some services coming into your home to help you clean, but you might not be able to consent to a complex surgery. So your substitute decision maker might step in there. They also have to support you for as long as possible to make the decision yourself. Another really important aspect of an advanced care directive is that there are binding refusals and non-binding refusals. A binding refusal is where you write in your advanced care directive some treatment, medical treatment that you don't want to have. So for example, at end of life, you might say, I don't want any life-saving measures. I just want comfort. I want to be surrounded by my family and that's it. That is binding on healthcare professionals and binding on your substitute decision makers to uphold that. Everything else in your advanced care directive is non-binding because things might change. Like you might want to stay home, but you might not be able to stay home in your home. It might be financially not viable. Okay, and there's one little plug for our dispute resolution service, of which I'm the manager of at the Office of the Public Advocate. We have legislative authority under the Advanced Care Directive Act to assist where there's any disputes about an advanced care directive or disagreement between decision makers. So you might appoint two substitute decision makers and you think that they're going to get along really well. Something might happen. They might start to have a bit of conflict. You can make an application to our office and we can try and resolve that. We do that via assisting parties to understand the legislation, but also via formal mediation processes as well. All right, I'm conscious of time. There have been a few amendments to them, but they're not that important. It's on our website. I'm sure Legal Services have it on their website as well, and SA Health's website as well. Thanks for listening to me, everyone.
Thank you so much, Kate. It's really, really important, this topic. It's so important to think ahead, plan ahead. And so thank you for informing us. So now we're going to move on to Simon. So Simon Dinning is the manager of the Personal Estates branch of the South Australian Public Trustee, responsible for the financial management of 5,000 of some of the most disadvantaged members of the community. With qualifications in law and financial management, Simon has significant experience in the trustee industry in both the private and public sectors. So Simon is going to be talking to us about dispelling the myth, the role of the public trustee. Welcome, Simon.
Thank you, Caroline, for that introduction. Can you see my screen, first of all?
We can, thank you.
Excellent. Look, I chose this topic because in our advocacy sessions with community support, disability support organisations and our customers, we've come to realise there are a lot of myths about what the public trustee does do, doesn't do, and why we do certain things. In the interest of time, I'm going to skirt through some of the early slides fairly quickly, just so we can get to the real meaning of what I want to talk about. So, first of all, public trustee. Public trustee is a person. There's a person appointed by the Governor and Council to the role of the public trustee, and there's an act called the Public Trustee Act that actually establishes what the public trustee can do and sets some parameters about the areas in which they can act. We have a couple of sections to our business. There is a deceased estate and trust section. I'm not going to be talking about that today. We have a corporate section, obviously, that looks after the regulatory services and all the corporate engagements that's required to run an organisation of this size. But where I'm involved is the personal estate management side. And that's primarily what I'm going to focus on today. And by personal estate management, I mean where we are acting for a living person to assist them in the management of their financial affairs. It's important to understand that we are appointed to act. We do not go out and seek an appointment. There will be a tribunal or a body, such as a court, who will say, we recognise that the person in front of us requires support in managing their financial affairs. There is nobody else appropriate to appoint, so that first they will look to family or other support from the community. But if there is nobody who is appropriate, they will appoint the public trustee to step into that role. 85% of the appointments we receive are through the South Australian Civil and Administrative Tribunal. We get 10% of them through the courts, and 5% of them are appointed by an enduring power of attorney by an individual actually consciously making that appointment of the public trustee. It's important to note that if a tribunal or court appoints the public trustee, we cannot refuse that appointment. We have to act. We, however, are not obliged to accept an appointment by under an enduring power of attorney, except where that's a sleeping appointment. And what that means is somebody will come in the prime of life and say, look, I'm conscious that I'm aging, but while I have capacity at the moment, there may come a time in the future where I don't have capacity. I have nobody else to assist me, so I'm going to make a power of attorney now in anticipation of some subsequent event. So we take those powers of attorney, we store them, we take no action on them, and if that person subsequently loses their capacity, then we can step in and assist them with their financial affairs. But we don't generally take on a power of attorney for somebody who has capacity. So the primary part of our business is an appointment as an administrator through SACAT. We don't determine what we do. SACAT determines what we can do in terms of the order that's presented to us. They determine who we can provide information to. So just because a person has previously had input into the financial affairs of a person, if SACAT does not provide us with the authority to actually engage with that third person in terms of the financial decisions that we're making, we cannot do so. SACAT can also instruct us that we must liaise with someone. In that situation, there is an obligation to us to consult with a person over the decisions that we're making, but that is only a consultation process. The information we are given is for our use, and it doesn't mean that the person who has been instructed to liaise with actually has any decision-making rights in terms of the decisions we make in relation to their financial affairs. And SACAT can limit our authority too. They don't just have to say, we have a person in front of us who needs complete control over their financial affairs. They can say they need help with a certain area of their financial administration. They can place whatever constraints on us that they wish to place in terms of reporting, who we can talk to, what activities we must do. So essentially, public trustee is not involved at the appointment stage. We will generally learn of our appointment when an order is received from SACAT telling us what we can do and who we can talk to. Our authority, much like the Office of the Public Advocate, comes from the Guardianship and Administration Act. The order itself tells us what powers we can exercise. The Act really gives us some definitions around how we exercise those powers. There are some different sort of authorities given to us when a court makes an order. There's different legislation involved, but generally we try and exercise the same sort of decision-making processes as we exercise under a SACAT order, where there is an administration order in place. It's important to remember we have a twofold purpose. It would be fair to say that historically we took very seriously our protective purpose and perhaps did not take on board so much our supportive purpose. There has been very much a change in our approach of recent times, where our supportive purpose under the Act, where we recognise that we are acting for an individual who has rights, notwithstanding they can't necessarily exercise sound decision making. So we are very much making decisions based on understanding what the customer would have done if they could have made the decision for themselves. What would they do now if they were able to provide us with some advice? What their circumstances when we took them on indicated to us about what they were trying to achieve in their financial life. Now, sometimes we do have to place a protective overlay over that as well. And that can be where we are aware that there are issues of financial abuse or undue influence. It could be where there are addiction issues. It could be simply that they have lost their capacity. But our approach very much is, first and foremost, what would the person that we are helping want us to do? And what do we need to do in terms of that to make sure that they are protected? The Act certainly provides us with some guiding principles, and they really speak to a personal autonomy and rights of our customers. And that is a strong focus that we exercise now in terms of any of our financial decision making. And our overlay is it affordable? Do we understand our customers' personal circumstances and any external influences on them? Is what they're asking for fit for the purpose that they want to do? Is there something more reasonably priced if it's something very expensive? And overall, is what we are proposing for them safe for them? So, for example, a person with addiction issues, we need to be aware that releasing large amounts of money is a problem. People who are under undue influence, we need to make sure that where we are releasing funds for a customer, those funds are being spent on the customer and not being misappropriated in some form. And it's really important to understand we do not impose our personal values on decision making. What I think is appropriate or inappropriate is irrelevant to the decision that we make. What is appropriate is what is in the best interest of our customer. What would they do if they had the choice themselves? That's a very, very strong focus. It's important to understand we don't act as a guardian. There is a separate office, the Public Advocate, and Kate is from that office. So we don't make lifestyle decisions, where people live, healthcare, who the people can associate with, support services they can get. It's also important to understand that we actually don't have any access to NDIS information. So anybody who is involved in the NDIS scheme, NDIS do not recognise us as a decision maker in terms of the NDIS insurance funds. We don't receive NDIS funding. We have no access to plans, and we do not make decisions about NDIS funding. It is entirely separate to us. It is federally administered. OPA can get access, so we have mutual customers. We can certainly have some input in that space. But if anybody's involved in NDIS and they have no guardian appointed, we don't have access to that information. And people don't often realise that. They expect us to manage the totality of their financial position, but we simply can't. We can only deal with the non-NDIS related funds. Is my time up?
Close to it. So if you've got
Close
one.
to it?
Hello.
So the only thing I wanted to note is, if you've got a financial or legal matter, that's our scope. If you have a lifestyle matter, it's the public advocate. There's a lot of grey in the middle of that. So if you just don't know who to go to, contact one or the other. We are in the same building. We work very, very closely together, and we will always discuss any situation where we're not sure who should be acting. It's our responsibility to sort that out, not the people that we're acting for. And the other thing is, you always have a right of review. You can bring in an advocate with you if you want to talk with us. You can ask for an escalation of a matter if you don't agree with the decision that's made. And there is provision on our website for us to consider any concerns that you have if you have some access to technology to actually ask us a question. I'll stop there because I'm sure we're getting pressed for time.
Thanks so much, Simon. I think that was a really important message at the end, so I'm pleased that you had that time to give the overview of your scope, and also making sure that it sounds like it's a no wrong door approach between you and OPA, which is great. So our final speaker of today is Sergeant Philip Gurr, who is from the South Australian Police, or SAPOL. So for more than 30 years, SAPOL have valued community engagement and provided advice on crime prevention through the establishment of the Public Engagement Unit, formerly known as the State Community Engagement Section. So Philip is presenting on home security, and we'll discuss how security can be enhanced. And I have to say, this is a really valued service. I was recently doing a couple of MP forums, and I can tell you now, the lineup of older people to see the police officers and hear how they can make themselves safe was very valued. So please, over to you, Philip.
Thank you, Caroline, and good morning, everyone. Let me just make sure that you can all see my slides.
We can.
How's that? Can you see that clearly?
Yes, thank you.
Great. Okay, so yeah, good morning. Thank you for your time. So the theme of today's presentation from me is going to be fairly short, and it's going to be on staying safe at your home. So for elderly people, I've tried to make it meaningful to people in a range of home settings. So either you're going to be an older person still in your home at your private home address, you might be in a retirement village type of setup, or you might be in aged care. All the dot points are not going to be relevant to everyone, but hopefully everyone will take something out of the dot points coming up for you. So the outcomes for today are going to be, we're going to be talking about some very basic, if you like, key top tips, if you like, about how you can help to keep your home safe and secure. We're then going to move on to the different ways that you can report a crime. And we're going to be contrasting 000 to 131 444, and then potentially a personal visit to a police station, and the idea and the themes behind each of those reporting options. We're then going to be talking briefly about a very important topic, scams and cybercrime, which impact on everyone, including older people. And then we're going to finish off with where you can go if you're a victim of crime, or if you've been affected by crime, where you can go to get further support. Okay, so let's talk about within the actual physical environment of the home, whether you're in your own home still, whether you've moved on to retirement type premises, or if you're in fact in an aged care community-based facility. And again, some of these dot points are not relevant to each of those sectors of the aged community. If you're in your own home, then clearly the first point I want to make is your external door, or your external doors, and also your windows, your external windows. People who enter homes as a trespasser, so they're entering a home to commit an offence, they are very often opportunists. And many of them take full advantage if they can find a home where the occupier has left a door physically or visibly open or closed but not physically locked. So the advice here is to get in the habit of making sure doors, external doors and external windows, if they're fitted with locks, use the lock whenever you go outside. And that doesn't just mean when you're leaving the premises to go away somewhere. It can include if you're going away shortly, out elsewhere onto your property or in the garden. And you'd be surprised how many burglaries, if I can use that term, burglaries or trespassing into your home, how many of them do actually happen, and the entry point is through an insecure door or window. So I can't reiterate that point enough. Lock your doors and windows at all times. Now, the second point is screen door. If you've got a screen door and it's got a lock, they usually do have locks, lock it. Screen doors don't always appear to be particularly robust, but you can get some very strong accredited approved ones. But every screen door that locks provides just one more layer of security, and it makes it that bit harder for someone to force an entry. Now, the third dot point here is relevant to whatever type of setting you live in as an older person. Make sure that you secure personal documents, including financial documents. And we're going back to the topic of today, really, securing your finances. Don't make it easy for someone, and it could be someone that is a family member or a friend who's allowed to be in your room. Don't leave personal things out. Don't leave checkbooks out. Make sure you leave bank statements secure somewhere. Don't leave them where they can record them or photograph them with their phone and use them. And when it comes to disposing of your documents and financial documents, don't just throw them in the bin. Don't throw them in your green waste bin. Okay, we recommend, SAPOL recommends that ideally all sensitive personal documents, including bank documents, should be shredded. Moving on to valuables. So items of high value, jewelry, that sort of thing, try not to leave them in obvious places. If someone comes in intending to steal from you, they're going to look on countertops. They're going to look on bedside cabinets. They're going to look in small trinket boxes. So don't leave jewelry in places where you think someone would know where to go to steal them. Think about less obvious places, and certainly don't keep them in plain sight. Moving on to keys. So house keys should never be left on the inside of the door lock. If you use the key to lock the door at night, remove the key and secure it somewhere out of sight and away from that door. For those of you that still own your own vehicle or have access to a vehicle, again, keep your vehicle key away from plain sight. Don't leave them on the kitchen counter or the fruit bowl. And I'd also recommend that you probably don't put them on a key hook. I know a lot of us keep key hooks. We don't recommend that you put keys on plain sight in a key hook. And just remember, many modern vehicles are extremely secure. And to steal a modern car, the offender usually needs the key or the keyless ignition fob. And offenders do enter homes to find the key or the key fob to then steal the car. So make sure if you've got a vehicle that is potentially a valued target by an offender, keep those car keys or the key fob away from doors and windows and not in plain sight. And the last dot point there is to use a safe. If you've got a safe, make sure that you use it. Small items of high value are best secured in a strong safe, either in the floor or on the wall or attached to a solid, robust part of the structure of the building that you live in. Okay, so we talk about the different types of reporting crime. So if anyone is familiar with SAPOL's website, or it's generally common knowledge, when you have an emergency, you can dial 000. When you have something which we would call a non-emergency, or you seek further advice, we recommend that you contact us on the 131 444 phone number. Now, what is an emergency to me may not be an emergency to anyone else. So I just want to touch on very quickly about what would a third party, a reasonable person, assume to be an emergency. Well, I would put that down. I would simply say to you, ask yourself before you dial 000, is the thing that you want to report something the police would want to get to quickly? So is it a matter of life and death? Is it a matter of serious damage being caused to property or infrastructure? So to give you an example, if you are witnessing what you think is a break-in, if you see someone climbing in through a house window, clearly it warrants an emergency 000 response. Things like a crime in progress needs 000, where if you want to report a historical crime, then the 131 444 number would be far more appropriate. Moving on to, again, the theme of today about financial abuse and financial security. Paul talked quite succinctly about restraining orders and what you can do to protect your rights if you believe you're being abused financially. And for an older person, it's probably a more likely scenario where you would seek to probably come into a police station to make a report based on financial abuse. And that would typically be set up by the person, the resident, dialing 131 444, getting through to one of our operators, explaining what the situation is, the fact they want to make or explore the options of making a restraint order, or rather an intervention order, as Paul described it, and then there'll be an appointment made for that person to go to a police station where they can sit down and make that report in comfort. Now, just quickly, we must touch on scams because they are extremely a major issue across the world for all sectors of the community, including older people. And some types of scams are more impacting, if you like, on the older community. So let's just start quickly with defining what a scam is. So in definition, a scam really is a method used by a cyber criminal to trick you into handing over your money or you revealing your personal identification. And scammers use a variety of methods to get you to do that. They use email, they may text you, they may personally phone call you, they might use a website or any other type of social media to make contact. And often that when they present to you, they may well present as someone that you think you know and you trust, or it could be even purporting to be a loved one. But by stopping and thinking before you respond and clicking on any sort of link, you can protect yourself from losing, 1, your identity, 2, your reputation, and 3, potentially even your life's monetary savings. So what are some red flags to help you think this could be a scam? Well, one is they use a trick to make you act quickly. They put a sense of urgency on their communication and they say to you, you must act within 24 hours to avoid this type of fine. They may come across with a sad story for you or a cry for help. It might be a request for a monetary donation from you. It might be an investment or you've won a major prize offering. And the key thing here is ask yourself, if the alarm bell starts to ring in your head, ask yourself, is it too good to be true? And if it usually is too good to be true, it's usually a scam. So don't react to it. There's also scams going around for people seeking romantic liaisons, relationship scams. And another big one is the Australian Tax Office. There was a big scam going around last year, and I think it will happen every year towards the end of each financial year, purporting to be from the ATO, saying you owe us money and you've got a short period of time to respond and pay the money. So these are some of the red flags to be aware of. So just to wrap up with the scams, the key thing is when you receive it, stop and think. Ask yourself, could it be a scam? Check the contact business or the individual using a publicly known phone number. Don't click on any links provided at all and act quickly. If you become a victim of scams, you must contact your bank. That is very important. and you need to ideally report it to ScamWatch, which you can do via the Cyberlink government website, or you can go onto the SAPOL website and we give you a link through to ScamWatch on our website. And if you think you've been approached by a scammer, even if you've not fallen for the scam, you can still report that type of scam through to ScamWatch, and they would welcome any information you can give them. Okay, and just to wrap up, we talked earlier on, I want to talk very briefly about victims of crime. So if you are a victim of crime in South Australia, SAPOL, or South Australia Police, we have got victim contact officers at every major police station, and they would be put in contact with you once it's flagged that you've become a victim of crime. There's also the Victim Support Service. They are not part of SAPOL, they're a separate government agency. They provide a community-based, not-for-profit guide. Qualified professional staff provide a comprehensive range of services for people who have suffered as a crime. So, and that includes either a victim or a family member or friend who's been affected by a crime. You do not necessarily have to be a direct victim of a crime to utilize their services. And then just finally to wrap up today, Doris spoke earlier on about Aged Rights Advocacy Service. They provide advocacy for people seeking or to understand and exercise their rights to live free from abuse, including financial abuse. And SAPOL see them really as maybe often victims come to us and we may refer them as part of our process to the Aged Rights Advocacy Service, and vice versa. Often Aged Rights speak to a resident about an issue going on, and they would often, as part of their service, refer the person to SAPOL to make a report if that is appropriate. So I think we're finished there, Caroline. I hope I didn't overrun too much, and thanks for your time.
No, you didn't. Perfect timing.
Thank you.
And I think these are really important topics for everyone to hear about. And so I would like to now open it up. I know we're running short of time, but maybe if everyone can switch their cameras on. And we have 4 questions here at this moment. So I might take it from, so can advocates help regarding end-of-life decisions and medical matters? If not, where can one get help? It may depend. So, of course, we support older people in residential aged care, so there might be something happening there. But if there was disputes involving advanced care directives, I would think that might be the OPA. Kate?
Yep, absolutely. Any disputes about advanced care directives or disputes between substitute decision makers making decisions under advanced care directive, and even the person themselves concerned about substitute decision makers making decisions that are holding their wishes, we can absolutely assist. Yep.
Excellent. The next question's about slides, but I do think everyone could see the slides as we move through because we tested them. So I think that one's answered. The next question is, what is the professional qualifications for advocates? Oops, it's slowing down. Will elder mediators be qualified? I can speak for ARIS. All of the advocates have professional backgrounds from humanities, law, financial counselling. We actually have, yeah, thanks, Doris. And Doris is sitting next to me, letting me know about a range of things. So we've got law, psychologists, nurses, social workers, financial advocates, financial counsellors. We have a CPA who works particularly in our financial statements section regarding home care statements, and we also look at aged care, residential aged care statements as well as a bit of an overview. We all have police checks, and the advocates participate in the Older Persons Advocacy Network Advocacy Academy across the country. and reflective practice. So I don't know if any of the other agencies want to comment on their backgrounds.
Certainly in our dispute resolution service, all our mediators are qualified mediators and have also done the elder mediation training as well. And accredited with the National Australian Mediation Association. Yeah.
Any other agencies want to comment, or we're all good? I think legal services are probably mostly lawyers or social workers. Yeah.
At the public
Yeah,
trustees. Sorry. You go.
I was going to say, yes, at legal services, if you're calling one of our advisors, you'd be speaking to a lawyer or a paralegal. But as you mentioned, we've also started to hire social workers increasingly now to work alongside our lawyers, with that recognition that our legal issues are often very much intertwined with our social stresses.
I was just going to say, the public trustee, there's no formal requirement for a qualification for the roles that we have here, but we have a large percentage of our employees have legal qualifications.
Thank you. So, and say, Paul, did you want to make any comment at all? No. So I think we've answered that question. The next question is, what examples of restrictions can an intervention order be put on an alleged perpetrator to prevent further financial abuse? I might ask Legal Services Commission. Oh, I think they've written a bit more too. And also for coercion control, what sort of specific restrictions could be made on an intervention order? Paul, would you like to answer that?
Yeah, so not to be too much of a slippery lawyer, but it's really going to depend upon the circumstances for the person who is experiencing that abuse. As mentioned, the idea is that we try and design it, or the court tries to design it as much as possible to fit that person's particular needs. You know, it may be that that person simply wants to have no contact whatsoever with the other party, but sometimes they want the abuse to stop, but for there to still be some form of contact. So it might be that contact is permitted, but there might be restrictions about the way in which that contact can occur, where it can occur, preventing somebody from coming to where that person lives. They might have to meet elsewhere, or they might have to meet with other people present. So it would really be about determining what the nature of the abuse is and what level of intervention the person wants to try and restrict that abuse.
Thanks so much, Paul. I think we're at the end of our session today, and I think we're going to have a poll put up onto the screen. Here it goes. So if everyone would like to provide some feedback on that poll. A few more seconds to go. All righty. Excellent. So I'm looking at the results, I think. Can I share? Oops. So I'm not sure if everyone else can see that. So overwhelmingly, the poll suggests that most people found it good to excellent, with 36% saying today's webinar was excellent, very good was 43%, good was 21%. And so well done to our speakers, and thank you so much for being present. We do apologise for a slight delay. Always challenging doing something when your internet goes down, probably 10 minutes before you're going to do a webinar. I do really want to thank Doris from ARIS, who has been a lead in this role for many years, Paul from the Legal Services Commission, Kate from OPA, who continues to do great work. Simon from Public Trustee. It was great to hear about the reforms and you know, the working together with OPA and Public Trustee, but that swing to supporting. And also, obviously, SAPOL. SAPOL do such great community engagement work. And I have to say, we've been the benefit of that community engagement. So Aris currently has about 5 or so what we call repurposed police officers working for our intake team. So we've had the benefit of having very much a multidisciplinary approach, and so we value our Alliance for Prevention of Abuse, and we thank you for being present for this webinar. Thanks so much, everyone. Have a great day.
Thank you.